The Royal Roundup is on! I'm John Levy. Do you care about the internet being taken over by a handful of monopolies? I'll be talking about why it happens and what you can do right now to help fix it. Let's go! There's something wrong with today's internet, and it comes down to monopoly. Online monopoly is the root cause of other problems too, such as censorship. When today's tech monopolies censor a user or an idea, I can observe two things. One, they'd never dare to censor if they felt their users might leave for some viable alternative. Users don't want censorship. They want to be able to see everything that's out there, and they wouldn't tolerate it if they had somewhere equivalent to go. And two, censorship wouldn't be such a problem if it was done by just one platform among many. If there weren't a monopoly, the information would still get out. Politicians of both parties agree that online monopoly is a problem, and there's an effort underway right now to try and discourage big tech from censoring by threatening their immunity under Section 230 of the Communications Decency Act. And the idea here would be that if the company fails a test of being politically balanced, then they could be vulnerable to being sued. Now you can click here to watch my video where I explain why I don't think that this Section 230 approach will work. I don't think it's the right road to go down. In this video, I'll explain what I think the right solution is. As I said before, I think that monopoly is the root cause of the censorship problem. So I'll be talking about what's causing monopoly on the internet and how we can stop it. I'll be explaining why I think that the concept behind Royal.com is the right concept at the right time. Now, I know that this is a big, bold statement, but if you hear me out, I think you'll see I can back it up. Of course, I'm not saying that Royal would ever be the sole solution. I would expect over time there would be other platforms that emerge that use the same model. And ultimately, I believe that there should be some changes to federal legislation, which I will also explain shortly. In order to explain the nature of the problem and how Royal addresses it, I've prepared this drawing, which I call currents. Before I get started explaining it, you should understand that when I'm talking about monopoly on the internet, what I'm really talking about is the post and share model. So I'm talking about Facebook, Twitter, YouTube, Instagram, TikTok, all of these cases where users post content and share it. I'm not addressing other areas of the web, such as web stores or online hosting services. What we've seen in the post and share world is that there are several different types of content that users want to post and share. A YouTube video is very different than a tweet, which is different than a TikTok. But from what we have observed, for each type of shared content, there will be a monopoly. One company that dominates the posting and sharing of that particular type of content. I'll explain why that happens. With the rise of alternative tech platforms recently, we've seen more post and share platforms spring up. But we know that the monopoly law of post and share applies. Each market segment will be occupied by a monopoly. Now, maybe the market wants a right-wing Twitter and a left-wing Twitter, and a right-wing YouTube and a left-wing YouTube. But the monopoly problem will still happen. It's just that the market will be segmented this way along political lines, which I'm not thinking is a good thing. The monopoly problem coming out of post and share is what this drawing currents is all about. So let me get into it. You're looking at this drawing currents, which is a picture of a sailboat. And that sailboat represents all of us. And you can see that it has rocks on either side of it. Rocks on the left, rocks on the right. And you have characters in the sky who are generating wind. Some blowing wind to the right, some blowing wind to the left. And it's drawn this way so that we can talk about, well, what are the factors in play that are driving the internet towards monopoly and what can be put in place to offset those effects. And what you're looking at initially is, I would say, the final version of the drawing where I have included the characters that represent the legislative changes that I would propose in order to offset the factors that are driving us towards monopoly. And we have characters of different types. We have some dinosaurs. Those represent existing laws. We have a cloud, which represents sort of an accidental state of the law that has been arrived at through some disagreement among judges. And you have angels who represent the legislative changes that I'm proposing. Finally, you have a bird, which represents the technological improvement of the internet and the hope and potential of the benefit that the internet can provide for people. Finally, at the top, we have a quote that I think ties together the solution, what I see as the problem and the direction for solution. And that quote is from Richard Posner, who is a judge and law professor and is probably the country's leading authority on antitrust. And the quote comes from the second edition of his book, Antitrust Law, which he was writing in the early 2000s, predicting the types of monopoly problems that we would be likely to foresee on the internet. And now that some time has passed, I would say that this quote has proved very prescient, and what he is predicting has certainly come to pass. So the quote reads, "The realization of internet network benefits may require monopoly or inter-firm cooperation in standards setting." Standards in this quote is referring to technological standards, not human standards like content moderation or something like that. The types of standards we're dealing with here are non-proprietary, non-patented techniques that anybody can use to exchange information between computers. These standards are what allow the internet to work, and they're what can save us from monopoly. Specifically, the standard that I will be urging to save us from monopoly is known as RSS. And I have a little distillation of the quote here, which is you have monopoly and you have standards and you get to pick one. So in other words, what Posner is saying here is that in order to receive the internet network benefits, you're either going to have monopoly or standards. Now he puts it as may require. I would say that we're years down the line, we've seen the monopolies form. He was right. They will require, is what I would put it, will require either monopoly or interfirm cooperation in standards. And so what I'm going to be proposing with these changes, and it's going to take some explanation, is the implementation of these standards to combat the monopoly problem. And a way to encapsulate that would be to say that when the network that we're talking about is the internet, where everybody's communicating under the technological standards that are forming the backbone of the internet, then you're not going to run into the monopoly problem. Where you run into the monopoly problem is where the network becomes the platform. So, for example, Facebook or Twitter, you are connected to each other not through the internet, not through a uniform standard of technology, but through the company itself, through Facebook or Twitter. You don't have a connection that is facilitated outside of the walled garden of those platforms. Now, there's a lot to take apart in this picture, and these are complicated topics where each one of them we could delve into at much greater length than what I'm going to do today. But buckle in, and I think that if you listen through, you will get a much better understanding of why we're in the predicament we're in and how we can get out of it. First, I'm going to attempt to describe this by simplifying the picture. Here we have a picture of the world as it is today, with the wind blowing to the right and driving this sailboat towards the rocks of tech monopoly. And I'm going to start explaining these characters that we have in the sky that are generating the wind. And in order to do that, let's cast our minds back to the 1990s. So we can imagine that the boat is parked in the 1990s. It's in these dark ages. We don't have the internet yet. And then the bird emerges, the potential for internet network benefits, where the internet had existed for some time just as a textual, mostly email or text bulletin board type thing that was used by some academics or in some scientific communities. But by the 90s, the technology had gotten to the point where it became something viable for the public to use. And so the bird arose and had the potential to blow the ship away from the dark ages of the 90s. However, there was already this copyright dinosaur that was blowing to the left. And it's going to take a little bit of explaining what I'm referring to by this copyright dinosaur in the sky. But there was a real concern in the 90s that the copyright laws were going to be so onerous on internet hosts that they would prevent the bird from ever getting the boat off of the 90s. That it's essentially that we would lose out on the ability to take advantage of the internet network benefits because of these particularities of copyright law. And I want to be clear, when I'm talking about the copyright law, I'm not talking about it in the way that most people would think about it. I'm not talking about platforms like Napster that were built for copyright infringement, where people would upload, say, copyrighted songs or movies or pictures and distribute them to other people and essentially perform mass piracy. That's not what I'm referring to. I'm referring to some wrinkles of copyright law that people today are typically not familiar with unless they're lawyers, but that posed a very serious threat to the internet even getting off the ground. So the aspects of copyright law that I want to note are its strict liability and its statutory damages. So strict liability was an important factor in this way. There is no requirement for you to be negligent or intentional in copyright infringement in order to have liability. And what that meant was that if you have a company that's running a platform or a bulletin board where anybody can post a piece of content, and some user, unbeknownst to that platform, posts a copyrighted whatever, a picture, a poem, a movie, a song, whatever it is. The user posts that, and the owner of that copyright sues the company that runs that platform. Under traditional copyright law, the owner of that platform is liable, period. It doesn't matter that they didn't know that there was infringing content up there, or even that they were taking precautionary measures and they were being perfectly diligent in trying to scrub anything copyrighted from their platform. If it's there, they're liable. That's the nature of strict liability. And that was something that internet platforms were subject to under traditional copyright law. And the second aspect of copyright law that was pertinent here is statutory damages. And what that means is that usually the rule in law is that you are liable for the harm that you do somebody else. So in order to owe them money, you have to show that they suing you have to show that you somehow cost them money or you somehow hurt them. But that's not true in copyright law. Copyright law has what are called statutory damages, which means that within the law that Congress has passed, there's dollar minimums that you are going to owe if you're liable for copyright infringement without any showing that your copyright hurt anybody, that the infringement rather hurt anybody. And so for a online platform, which is dealing in thousands or tens of thousands or more posts, the statutory damages could very quickly stack up to bankrupt any platform. And so those aspects of copyright law, the strict liability nature, where you don't have to be the one infringing if it's on your platform as a result of some other user's action, that would create your liability, and that the plaintiff does not have to show that you actually hurt them in order to collect money from you. Those two aspects of copyright law, it was feared in the 90s, I think very reasonably, that would prevent the internet from being able to take off and become what it can be. And so in the 90s, this other dinosaur was put in place that is blowing to the right. Okay, so the copyright is blowing to the left, and Congress was worried that it would have the effect of preventing the ship from ever leaving the dark ages. And so Congress passed this other dinosaur, which is 512C of the Digital Millennium Copyright Act. And that is blowing to the right, and it is counteracting what we're getting from traditional copyright law. And 512C, what it does is it creates an exemption for content that is posted by a user. Specifically, it says that is stored at the direction of a user. And essentially, it creates a safe harbor where if the platform meets certain requirements, they will not be liable for copyright infringing material that their users posted. And so Congress passed that. It has had positive and negative effects over time. And that's something that I should point out about these dinosaurs. Just because they're depicted as dinosaurs, that's not me creating some claim that it's a bad law or some inference in that regard. It's just that these are the existing laws. And as I'll explain shortly, I think that some laws are needed to fill in the gaps that these existing laws have. But so the 512C rule was passed, and that effectively blew to the right, counteracting the wind to the left from the copyright liability. And so now the Internet Network Benefits bird that's blowing to the right was able to move the ship away from the 90s. However, there was a unintended side effect of 512C, and that was that it created a major advantage for post and share platforms, because what happened de facto for post and share platforms is that they essentially got a kind of permission to violate copyright laws, because what they would do is they had these users that had sort of an aligned incentive. The platform wants many users to use the platform, and the people posting to the platform want many people interacting with their posts. And so what would often happen is that a user of the platform would post something copyright infringing, say some popular song, and the platform would receive the benefit of real traffic of people going there to listen to the song. The user would receive some sort of benefit too, because their channel becomes more popular. And so essentially they could work in tacit union in order to violate these copyright laws, allow people to see this infringing content. And yes, 512C has a process for notice and takedown, etc. And in theory, the user that was the one that posted the infringement content could be sued independently. But in practice, it was generally that the copyright holder would have their beef with the platform, and that would always be resolved in the 512C framework, not through any kind of liability where the platform has to pay money, but where the platform just has to take it down. So 512C, in short, had an unintended consequence of creating an advantage for these post and share platforms. And that brings me to a discussion of why post and share blows to the right, and why the Internet Network Benefits bird blows to the right, and even all the way to tech monopoly. And that has to do with the fact that the network benefit through a shared standard, like the Internet Backbone technological standards, that is very different from a network situation that is within the control of any given platform. Once you are in the post and share world, where you're essentially within a walled garden of one platform, where you only see the content through engaging in that platform, you are now creating a situation where everyone wants to be where everybody already is. Everyone wants to be where everybody already is, and that creates a snowball effect towards monopoly. And the advantage of shared standards, if you can see things essentially without being there, if you can distribute the information outside of the walled garden of these post and share apps, that's the potential for receiving the internet network benefits without falling into the monopoly trap. I'll explain that a little bit more in a moment, but first I want to explain the cloud. The cloud does not represent any intentionally created law or statute, but instead is disagreement among judges about what the copyright law means. So one of the areas of exposure that you have is that there are many ambiguous questions in copyright law that judges struggle with, and it actually happens a great deal in this area, that you have what we call circuit splits, where judges in one part of the country read the law one way and judges in another part of the country read it a different way. And that can be terribly damaging and dangerous for these platforms, because the platforms do not get to camp out with the law of the place where they're located. The rules for this are that anywhere where people are able to access material through your platform, a plaintiff can sue you there and can use the law of that location. So if there's 50 states, if there's one state where the judges are disagreeing with the other judges and have a particular construction of the law that would make you liable, then that's a real risk to you. And in copyright law, where there are so many circuit splits, the dangers just multiply. And it's made even more severe by the fact that when you're dealing with a strict liability tort, which is what copyright infringement is, there is no corporate veil. You can't put this in an LLC, or a corporation can find the liability in there. Whoever is the individual working to run the platform is going to be personally liable. So it might be a situation where judges disagree, you get a bad bounce, and it is in a jurisdiction that gives you the plaintiff-friendly construction, that finds that you have violated, and there you go, personal bankruptcy. That's the kind of risk that these copyright legal ambiguities can create. And I've listed here two very important ambiguities that are hurting the internet right now, and those are the Aereo decision from the Supreme Court in 2014. This is another rabbit hole that we could go down for a long time, but essentially at issue in Aereo was that the court was evaluating a situation where you had a middleman who was engaging in a service and was collecting information that, so perhaps the user could have collected this information, but instead they contracted out with some other service to do it that was collecting information for them and then packaging it and giving it to the user. And the court, based on a very particular factual similarity to old cable TV systems, found that to be violating a copyright. And it created this great ambiguity of when these middleman services are going to be doing permissible activities versus when it would be copyright violative activities. And there's disagreement within the Supreme Court itself about how broad the decision was. The decision itself called itself a narrow holding, but Justice Scalia dissented, saying that there is no real limiting principle to draw from the decision, and that it's going to throw lower courts into confusion and disagreement. And that seems to have been borne out, with some circuits saying that it's a narrow decision and some saying that no, it's a fully broad decision. So that's created a lot of ambiguity. And then the second area of judicial confusion that is hurting the internet that I'm drawing attention to here is the server test circuit split, where essentially the issue here is, let's say that I have a link to a picture. Okay. If I sent you the picture, because I don't own the copyright to the picture, if I sent you the picture, that would be a violation of copyright. But I have the web address of the picture, and I send you that as a piece of factual information. It's just an address that will allow you to locate the picture. And I do that in a way where your browser will include it as an embedded image. Is that a display of the pictures? Is that creating a copyright violation? And some courts say yes, some courts say no. And that's another area of ambiguity that's hurting the internet. And now I want to get to why I have this drawn, that these aspects of legal ambiguity are flowing to the right, that they are combining with the 512c advantage for post and share. And the reason for that is that 512c has a particular test that it applies when you're in the post and share environment. And what it says is that the post and share will not be creating liability to the platform unless the activity had, quote, apparent infringement. And so this was an area of litigation 10 years ago or so, to 10 years plus, where people were posting infringing material to the internet, and the plaintiffs whose material was infringed claimed that the platforms should not support the sharing of material, because they should support instead what were referred to as sort of digital lockers, where you could store your material but not show it to anybody else. And much of how the internet looks today is the result of courts resolving that question in favor of the idea that the platforms can share and distribute that posted information because there's no apparent infringement. There's no reason that they would know that what they're doing in that context is infringing. So what that means is that because of that text in 512C, once you're in the 512C post and share environment, you actually are not really quite in the usual strict liability rules for copyright. Instead, you're going to be okay unless you're engaged in apparent infringement. So that's another aspect of why post and share now has become so predominant on the internet, that they receive protection even from some of these areas of ambiguity. So there I've covered the picture as it stands now and why post and share has come to predominate, because the legal rules have carved out special exceptions that make that much safer for internet providers to do, and why the post and share model is inevitably rolling us towards monopoly. Now I'm going to give you the next version of the drawing that shows how Royal fits into the picture. So this is what Royal is trying to do to combat the winds blowing to the right and try to bring some balance to the system. Now, the way I've drawn it, it makes it look like, oh, Royal's going to fix it. It's counteracting all of these winds. That obviously is highly optimistic. I don't think that it makes sense to say that Royal will be able to do it alone, but Royal is part of what I think is the right direction in trying to combat this problem. So referring back to the quote from the beginning, which you have at the top of the drawing, that you have to deal with monopoly or standards, choose one. And Royal is trying to leverage the existing RSS standard to give us the internet network benefits without us driving the ship all the way to monopoly. The way that Royal functions is that it receives from many different sources on the web listings of what posts those sources are now offering. And it allows users to see, without being within any of those walled gardens, okay, here are the posts that are on offer now, and allows people to navigate to them. Now, obviously, Royal's not taking the post and posting it on Royal, because that would be a copyright violation. We don't have the permission for that. Instead, it's almost like the library card catalog. So it's going to show you by default just the title, who the author was, and when it was published. And it's enough information, like with the library card catalog, to allow the user to decide, do I want to go into that walled garden and check out this post? But it allows you to see it from another location. It allows us to return to the notion that the network is not the platform. The network is the internet more broadly. So that explains how Royal is combating the wind to the right that's coming from internet network benefits, and is hopefully allowing that wind to be counteracted right in the middle, right? So the goal is to create a steady state where the boat is stable. We're not back in the dark ages. We're not on the rocks of monopoly, but we're stable sort of in the middle. That's the branch coming out of Royal to the top. And then the branch coming down to the bottom is a different sort of mechanism, which is the Royal claimed feeds model. And that claimed feeds model is that the owner of a feed can give Royal permission to show somewhat more than the library card catalog. And that's something that is always going to be up to the owner of the feed, the owner of the copyright. And it allows for essentially some of the content on Royal to fall within the 512C user-directed content exception, because here we have users who have proven their ownership of these feeds and that are directing Royal to make more available with respect to their posts than just the library card catalog version. So that explains why I say that Royal is the right platform at the right time. It is doing the things that are designed to combat these forces that are driving the whole internet towards tech monopoly. And it's what we can do now in the absence of any kinds of changes in legislation that might restore some balance. And the final version of the picture, I'm now going to bring you back to the first one that I showed you. So this is including the legislative changes that I propose. And the legislative changes here take the form of angels. And so the first angel, who's blowing down and is sort of counteracting the winds that are coming from the cloud, that is copyright reform, which is going to clarify and resolve some of these disagreements among judges. And I think that it's very important that we do this. The last time the Copyright Act was really revised was 40 years ago or more. And a lot has changed since then. That was before computers were a factor in our lives. And there's a real need to resolve some of these questions, like the questions raised in Aereo, like the questions raised in the circuit split of the server test. And it's a real necessity, or a real promising area for Congress to step into, because what happens, there's two ways this can get resolved. One, Congress can speak and decree, okay, here's how these issues are going to be resolved. Nationwide, it's all the same. Or the other one is that it's going to have to happen case by case, piecemeal, in different jurisdictions with different courts. And that process will take 30 years, 50 years. And there's we don't have that time. There's no reason for that delay. And so I think that we need some copyright reform to clear up these issues that are coming out of the cloud. And then the other angel is to make the 512c copyright protection contingent upon support for this RSS standard that will allow interconnection, that will allow users to see what is available without being in the walled garden of any of these apps. And the interconnection, what it will allow is it will break this pattern of ever escalating monopoly and ever increasing drive towards monopoly that comes from the fact that when you have a walled garden, everyone wants to be where everybody already is. But if you can see at least some kind of preview of what is available, of what posts are there from outside the walled garden, then you're able to participate in many different platforms all at once. And this RSS standard already exists on the internet. It's already very widely used. It's supported by many, many websites. There's no question that any platform that chooses to support it could. It is tried and true technology. And I think that that is the direction that we should go in trying to address this problem of online monopoly. So that is my explanation of the currents drawing. Thank you so much for watching. And I hope that you now understand why I say that Royal is the right platform at the right time to confront the monopoly problem that we're facing on the internet. I really hope to see you on Royal. It is a great, fun-to-use platform that will help save us from monopoly. You can sign up at royal.com, and you can interact with the Royal team at forums.royal.com. I hope to see you on Royal.